but I'm pretty sure we're yep, copacetic. Let's press play. The Australian accent is delicious.
All right, Mr. Clark, we about ready to proceed?
Yes, I'm just finishing one letter.
All right.
Yes, we like to start with nothing and work our way up to frustration. We're just watching nothing. I wonder why this trial went on so long. I guess we'll never know.
All right, Mr. Clark, are we ready?
It's a mystery.
Address these items individually when the court is ready.
All right, let's proceed.
All right, the defense has obviously handed us a number of different items. I'll start with those which we do not have an objection to. And in terms of describing them, we have been provided what appear to be a staple package of 6 charts that look similar to the charts used yesterday in court on the overhead projector, including the summing of genotype type charts. And at this point, assuming a proper foundation is laid, we have no objection to their use. We also received what appear to be smaller versions of what I anticipate will be slides used with the witness. 2 of them refer to the steering wheel and contain something of a diagram, and again, assuming a proper foundation is laid, we have no objection to them. There are, however, in addition to that, what...
Hi, Bill. Bill, I was bragging all over your birdhouse. I'm sorry, I don't know what it is. That birdhouse was so cool. I keep thinking about it. I'm telling you, if I was walking by that stupid birdhouse in Walmart, Target, whatever store, just pick a name, I would have bought it. I don't know why. That would have came home with me. That birdhouse. Bill made a birdhouse. It was really cool. I thought it was just a red birdhouse. I don't know. It kind of reminded me of Snoopy. And which is a doghouse. I know the difference between a birdhouse and a doghouse. But he made a high quality birdhouse. It just hit. It was fire. Fire.
appear to be 6 slides with the cover of the National Research Council report and then various portions from that particular report. Our objection is the same as it has been previously with regard to hearsay in Evidence Code Section 721. So I'm simply alerting to the court that that will be an objection.
And I've never had a birdhouse before.
And I don't believe the defense should be able to either read from it or put a slide on the board until a proper foundation is laid under 721. There is a one-page table of what appears to be a frequency chart, a database-type frequency chart, that again, assuming a proper foundation is laid, we have no objection to it. And then there are 2 sets of documents, one of which is appears to be a copy of the unpublished letter to Science magazine that was a topic of discussion in this court some weeks ago. Our objection remains the same to it. Obviously, hearsay has not been published in the scientific literature. And again, I just want to alert the court if the defense attempts to bring out contents of the nature of this report without otherwise providing a proper foundation as to its hearsay nature, then my objection probably will be rapid. And what has been provided to us, the last item appears to be a series of 4 letters, I'm sorry. Some from Dr. Weir and at least one to Dr.
I would just ask that, since I think it's the court's rule on discovery, which is going to be used for cross-examination, that it not be shown to the witness while he's being cross-examined, that for this discussion, I would simply ask that the witness step out of the room.
Nope. These are a number of letters, and again, unless there's a proper foundation, they're obviously hearsay at this point. So I just want to alert the court that any attempts on the defense's part,
But if they're letters of Dr. Weir's, they could be prior inconsistent statements, etc.
they may be, that's what I mean.
Okay.
In other words, I'm assuming a proper foundation will be laid for all of this, but I want to alert the court that my objections may be very quick and very vocal about items that this court has already resolved.
All right. Thank you. Anything else?
Yes, Your Honor. Just, I'd like to actually have one comment on the National Academy of Science report. Your Honor, I have looked at some of the case law in California since we addressed this issue last with Dr. Cotton, and I frankly have not found any case which says that that the witness can pick and choose within a chapter, within a learned treatise, and say that he can be cross-examined as to a portion of a chapter which he relies on, but if he doesn't rely on another portion of the chapter,
Well, let's see what the foundation is.
Okay, I also want to call the court's attention to Witkin. And Witkin says very specifically, Your Honor, that, and I quote,
Which edition?
I would have pulled out Wiccan
Witkin or
4 weeks
Witkin
ago.
Epstein?
Witkin 5, Cross-Examination of Expert Witnesses, Section 1899 at Sec.
Well,
Oh, we
Witkin
got
says
the,
it
we
must
got
be true.
the, what is, what a trauma-inducing shot we got right there, guys. We got Newfield, which really, oh, God. Then we got the, right beside him, we got that grinning lawyer. Ugh. Then we got a murderer, and then we got a charlatan. Ugh. The amount of emotion in this one picture, you know what, this is my thumb for tomorrow. Hold on, guys. This is definitely my thumb for tomorrow. Ugh. Ugh. Oof. Oh, sugar, my daughter. I have to get my daughter to school. Work. She doesn't go to school anymore. Oh, now she's yelling at me. Oh, don't do that. Oh, don't do that. There. All right. I have to get my daughter to work. I will be right back. Behave.
And the statement in Witkin, Your Honor, is, and I quote, similarly, it is important to permit an expert witness to be cross-examined concerning those publications referred to or considered by him, even though not specifically relied on by him in forming his opinion. An expert's reasons for not relying on a particular publications that were referred to or considered by him while forming his opinion may reveal important information bearing upon the credibility of his testimony. I would also point out, Your Honor, that this witness cites the NRC report in his report that was filed with the court and given to counsel.
Well, like I said, let's see what the foundation is.
Certainly.
All right. All right, let's have the jurors. All right, thank you, ladies and gentlemen. Please be seated. All right, the record should reflect we've been rejoined by all the members of our jury panel. And Mr. Neufeld, you may commence your cross-examination.
Good morning, ladies and gentlemen. Okay. Good morning, Dr. Weir. Dr. Weir, we've met before professionally, have we not?
Yes, sir.
But we've never encountered one another in a courtroom before this, have
I
we?
believe not.
Okay. Dr. Weir, you said a moment ago at the conclusion of the direct examination that in assessing the estimates provided by the Department of Justice in California and Selmark, that you felt that they were, quote, good estimates, unquote. Is that correct?
Yes, I do.
But they're not the best estimate, are they?
Well, I think based on those data, they are the appropriate estimates, and for a single point estimate, I believe they're the best, yes.
Well, let me ask you this, sir.
Excuse me. Doctor, would you just pull the microphone a little bit closer? Thank you.
Do statisticians use the term best estimate when supplying a certain statistical estimate of the occurrence of something?
Not generally. We have more specific terms, and we probably need to explore that further. Best is kind of vague, we might talk about.
Well, let me ask you this, Dr. Weir.
Sorry, counsel. He was in the middle of his answer.
Oh, I'm sorry.
I'll finish.
Apologize.
No, I'll stop.
Do the estimates that are provided by the Department of Justice and Cellmark in this case incorporate the corrections that you deem appropriate?
Well, that's a two-part question. As with the other labs, I produce an estimate by multiplying numbers together. That's the estimate. That's what I characterize as being a good estimate. Along with that estimate, as I explained yesterday, I would do two additional steps: attach confidence limits and allow for population structuring. And those additions have not been done by the two labs.
Okay. So if you were giving the best estimate in this case, it would, number one, it would account for a substructure. Is that correct?
No, I think what I said is the best estimate is what they have done. Along with that estimate, I would do these additional two steps.
Well, and when you do your additional two steps, you come up with a new estimate. Isn't that correct, Dr. Weir?
That's right. As we explained yesterday, we have, in public opinion polls, we have two parts to the answer, the 47% and the plus and minus bit.
And so, Dr. Weir, if you made your additional step, which is the result of accounting for possible substructure, that would come up with an estimate which would be more favorable to the accused than the estimate provided by Cellmark and the Department of Justice. Isn't that correct?
That's true.
And, sir, the other procedure or step that you take that was not taken by Cellmark and the Department of Justice is to include what you just said a moment ago were called confidence intervals, correct?
That's right, yes.
And if you provided a 99% upper confidence limit to the numbers provided by Cellmark and DOJ, you would again come up with a number which is more favorable to the accused than the estimates that have been provided by Cellmark and the Department of Justice. Isn't that correct?
That's right. Their original estimates, of course, remain good estimates, but along with those good estimates, we attach the second part of the answer. We say, here's our good estimate, and here's our confidence limit. Here's our good estimate, and here's an appreciation of how it will change with population structuring.
And
It's not correct to characterize one as being right and one wrong. The answers are, as you appreciate, are complex, and they are multifaceted. What we've seen on the boards here is the simplest interpretation.
Sir, all I'm asking is, would you agree that if you make the additional two steps that you've suggested, namely for substructure and for confidence intervals, which were not done by Cellmark and DOJ in their testimony, you would arrive at an estimate that is more helpful to the accused?
Well, I don't think that's quite saying what I said. We have the estimate as presented on the boards here. Along with that estimate, we give a range and showing how it would change. It's not that we're pinning our faith on any one of these single numbers. We can't divorce the estimate from the range. They go together. So we don't, it depends on your point of view, I suppose, but the President would be happy with the 47% because he would add on the 3, and the opponents would be happy with subtracting it. Of course, they're both stretching the limit. The fact remains the data support the 47%, and along with that, so it must be a compound answer. The extreme limits will be more favorable to the defendant, of course. The estimate remains the good estimate.
Sir, but by taking your two steps, you will get a frequency that is more common than the frequency articulated by Cellmark and DOJ. Is that correct?
I will be presenting a range. I'll be giving the original estimate together with the range. The outside end of that range, the very outside end of the range, will be more favorable to the defendant.
And it's that outside end of the range which was not presented by Cellmark and the Department of Justice, correct?
That's true.
And you advocate that those outside ranges be presented to a jury, don't you?
Well, I don't really have much choice. As a statistician, I need to explain estimates and the ranges. But I think, as we'll see, and I think I said that the amount of difference does not change the conclusions that we've heard. A matching profile based on several loci is a rare event. The fact that it's rare, and that's all I believe that we should be worrying about, the fact that it's rare. That fact is not changed by any of these manipulations of the numbers.
Let me ask you this, Dr. Weir, just to change gears for a second. During your career, sir, have you ever made any mistakes as a professional?
Oh, I'm sure I have.
Have you ever made errors in either calculations or computations?
I'm sure I have.
Have you ever, in your career, asserted facts that turn out not to be correct?
Well, you'll probably refresh me with some. I hope not.
Okay. Would it be fair to say that you may have made mistakes during your career, in certain facts that were asserted.
I may have made a mistake in my career, yes.
Okay. And would you also agree, Doctor, that perhaps you've even propounded theories that at some time in the future ultimately are refuted?
I don't believe so. I can't think of any published refutations of any of my papers.
How about unpublished refutations? In other words, I'm sorry, let me clarify that. Have you ever propounded a theory not in a publication or not in writing which was subsequently refuted?
Goodness, I don't know how I could answer that question. If I didn't say it or write it, how could I?
Well, I'm asking if you verbally expressed it to other people or to colleagues in the field.
Oh, I can't be held accountable for every coffee conversation I may have ever had.
Okay. Now, I believe you said on direct examination that you yourself do not operate a forensic laboratory. Is that right?
I do not.
And you've never operated a forensic laboratory, have you, sir?
I have not.
And in fact, you don't do forensic testing of any sort, do you?
I don't do any laboratory work of any description.
Okay. And would it be fair to say also that you have no training in forensic science?
That's correct.
Now, but you would agree, sir, that it's not necessary to have training in forensic science or to operate a forensic laboratory in order to provide an expert opinion on the appropriateness of certain statistical methods that are being used for interpreting forensic DNA data.
I would have to agree with that because that's what I do.
Okay. And would you agree, sir, that the relevant areas of expertise in this particular subject include theoretical population genetics and the field of statistics?
Yes, that's right.
Now, would you agree, sir, that there are often misunderstandings, if you will, about what statistics mean and what they don't mean?
I'm a statistician. I can't imagine that ever happening.
Okay. Well, let's just try and clear up a few things for those of us who aren't statisticians, sir. Would you agree that the numbers that are reflected on the prosecutor's exhibits in this case are not the probability of Mr. Simpson's guilt or innocence?
That's absolutely correct, and nothing I have said or will ever say has to do with the probability of guilt.
I appreciate that. And would you agree, sir, that these numbers that appear on these boards are not the probability that someone other than Mr. Simpson is the source of any particular stain?
No, I think we've been very clear what these numbers are. These are the probabilities or the frequencies of finding those stains if they were contributed by unknown people. And I'll say it once more because it's easy to get confused. These are the frequencies of the stains, be they single or mixed, if they were contributed by unknown people.
So, just so I'm clear on this, Dr. Weir, if someone said or suggested that these frequencies were the probability that someone other than Mr. Simpson was the source of a particular stain, that would be scientifically wrong, correct?
That would be wrong.
And the numbers up on this board and the other boards, Dr. Weir, they tell us nothing about the probability of a false or misleading match due to errors in the collection or handling of samples. Isn't that correct?
These numbers on the board are the frequencies of the stains if they were contributed by unknown people. That's all they are.
Well, sir, therefore, would you agree that these numbers tell us nothing about the probability of a false or misleading match due to errors in the collection or handling of samples?
These numbers are the frequencies of the stains, so that's all they are.
And therefore, they are not the probabilities or frequencies that I just described. Is that correct?
That's right. They are the frequencies of the stains if they were contributed by unknown people.
And, sir, would you agree that these statistics that have been propounded in this case by prosecution witnesses tell us nothing about the probability of a false or misleading match due to evidence tampering?
These numbers on the boards reflect only the frequencies of the stains if they were given by unknown contributors. That's all they convey. They don't convey any of these other things.
Well, and by your answer, sir, are you therefore saying that they don't tell us anything about the probability of a false or misleading match due to evidence tampering?
Sustained.
I don't believe it was responsive.
It was. Proceed.
And would you agree, Dr. Weir, that the numbers on these boards are irrelevant if the match is due to the combined effects of total degradation followed by cross-contamination with Mr. Simpson's blood, either from Rockingham swatches or from a minuscule amount of fresh blood from his reference sample?
Objection vague. Subtraction on evidence.
It's compound.
Also argument.
It's compound.
Right.
Rephrase it.
Would you agree that the statistics on these boards, Dr. Weir, is irrelevant if the match is due to the combined effects of total degradation and cross-contamination with Mr. Simpson's blood, with Mr. Simpson's blood from the Rockingham swatches?
I'm not sure I'm here to talk about relevance. These numbers that I have verified are the frequencies of those stains if they were given by unknown contributors. As I think I said, my analysis starts with the determination of the laboratory that there is a match, and these are the details of the matching profile. All of the numbers refer to the frequencies of the stains that are presented on the board. They make no statements about anything else, and I'm not talking about relevance. That's beyond my expertise.
In fact, Dr. Weir, would you agree that the validity of all of your estimates and the estimates propounded by other prosecution witnesses in this case assume that the laboratory work in this case was valid?
The validity of my results are self-contained. They follow from the profiles given. Once the profile is established and declared to match everything else I have done is valid, anything before that step I don't address.
Well, you say you don't address it, but you assume that all the work was done and all the results are valid. Isn't that correct?
I think I've said that. I assume that the facts on the board are indeed the truth. They are the profiles, and they do match.
Well, it's not just that they are the profiles. You're also assuming, sir, the validity of the underlying processing, collection, preservation, and handling of the evidence by everybody who did the work up until the time that you analyzed it. Isn't that correct?
I said that I'm going to start with these profiles and the fact that they match and the details of them. Anything that goes prior to that's beyond my expertise.
Well, let me ask you this, sir. Referring to your report, if you will, do you have a copy of it in front of you?
Yes, sir.
I call your attention to page 2. Oops, sorry. On mine, it's page 3. You state the following, and I quote, "These notes assume the validity of all DNA profiling by Cellmark Diagnostics, the California Department of Justice, and the Federal Bureau of Investigation." Is that correct?
That's right. I think that's just what I've been saying. I start with the determination of the match and the nature of the profile. Anything prior to that is beyond what I do.
Well, you included, along with Cellmark and the Department of Justice, the Federal Bureau of Investigation. Is that right?
Yes, sir.
Are you aware of any DNA profiling that the Federal Bureau of Investigation did on evidence samples in this case?
No, I'm not. But it's obvious why I have that statement in there. My entire report is based on the FBI data. I must assume that those data are an accurate representation of the profiles of the people sampled. I have no choice but to assume those databases are valid.
Now, Doctor, it's curious, however, that when you assume the validity of the DNA profiling of those different laboratories, you don't, or you fail to state whether you assume the validity of the DNA profiling done by the Los Angeles Police Department in this case.
Overruled.
That's omitted from your statement, is it not?
That's omitted from my statement.
And are you aware, sir, that the Los Angeles Police Department conducted DNA profiling in this case?
I became aware about 8 p.m. last night.
Well, when you became aware of it at 8 p.m. last night, did you feel it was necessary to amend your report?
If I had have had time after I finished working at midnight, I may indeed have done that and added in the words LAPD.
Are you aware, sir, that it was the Los Angeles Police Department that was responsible for the initial collection, preservation, packaging, and processing of the evidence in this case?
Not in any great detail, no.
And would you agree, sir, that if the DNA profiles in this case were the result of laboratory error at the Los Angeles Police Department, then all of your statistics, whether they're 1 in 50 billion or 1 in 5 million, would be meaningless?
Overruled.
All of my statistics are completely meaningful because they contain with them a complete description of what they assume. They assume that these are the profiles, that they match, that they have this particular nature. With that starting point, everything else I've done is valid. It is certainly not meaningless. Everything I have done, I believe, is meaningful, given the starting point I've described.
Sir, so what I'm asking you then, if in fact the DNA profiles were the result of error, then would your statistical estimates be meaningless?
All right, Mr. Neufeld, this is the same question we've now asked for the 8th time. Proceed. I'm going to sustain the objection.
Now, on direct examination, you discussed with this jury, or described to this jury, that when you use the product rule and you multiply these different frequencies, it is essential that the various factors that you're multiplying together are independent of one another. Is that correct?
Yes, they must be. We're regarding this profile as a set of pieces of information, and it's typically 10 or 12, sometimes it's even a lot more, separate pieces of information. And when I say separate, that means we are assuming that, in fact, they're independent. It's not, although we talk about the matching profile, it's actually a lot more than that, because the word profile is a word to describe a whole lot of matches. There are matches at both the bands of all the probes. So it's a very, if you like, very compelling event that we have this complete match. It's compelling because we regard these as being separate items of the match. And to put a number on that, we have to regard them as being separate and independent so we can do the product.
And I believe you said, Dr. Weir, yesterday morning to this jury, or yesterday afternoon, excuse me, when you were discussing the factors which suggested independence here, I believe that one of the things you said to the jury was that the marker systems that they're relying on for forensic typing are what is commonly referred to as junk DNA. Do you remember saying that, sir?
Oh, I don't think I said that. I hope I said that this is DNA of no known function.
Okay. And you said that because the marker systems that they're relying on for forensic work are DNA of no known function, that's an additional piece of evidence, if you will, to suggest that there's no association here. Is that
No,
correct?
no, I didn't say that. I said because the RFLP types have no known function, we may expect them to be independent. However, we are not entitled to go on expectations. We must perform the tests that I described and did indeed conduct, and it wouldn't really matter if there was some biological agent at work affecting these various pieces of DNA, these various types, providing the data, providing their frequencies are consistent with independence, then we may proceed with the assumption of independence and do the product rule. So when I do my test, it's a statistical exercise. It makes no statement about the underlying biology. Some of these pieces of DNA may in fact be very important for our well-being. We don't know that. And why I say they may be important, because if they were important, it might be that people with a certain type of DNA don't live as long, don't have as many children, and that would affect the frequencies. There is all that kind of phenomenon that may be going on. We don't think it is, but it may indeed be. However, when we look at the data, when we look at the databases and the frequencies, we find that these frequencies are consistent with being independent. So as a statistician, I'm doing a statistical test. I'm making no statements about the underlying biology.
Well, Dr. Ware, are you aware of the fact that for many of the PCR forensic markers that are relied on in this case, they do code for proteins, and they do have some effect on our health and well-being?
Some of the PCR markers are indeed inside genes, and they could very well, as I've just described, have an effect. What is kind of interesting, I suppose, and it's certainly reassuring for this forum, is that their frequencies are consistent with independent. Their frequencies show that, in fact, we may multiply them together, regardless of what effect those DNAs actually have on us.
A moment. You know, this morning and yesterday, sir, you provided this jury with an approach to interpreting the mixtures. Is that correct?
Yes, I did. We have given some numbers now which show us the frequencies of these various mixed stains if they were contributed by people unknown to us. That's what all these numbers mean, and certain specified numbers of unknown people.
And when you provided this information to the jury, you simply provided what you found to be the most common frequency, and then you gave the range to the rarest frequency. Is that right?
That's right, yes.
But you also, at least in your report, provided in tabular form a whole range of different frequencies depending upon the racial composition of two people or three people or even four people who may have been contributors. Is that correct?
I think, yes, I think all these numbers do that. All these ranges, as we've said, talk about the frequencies of the unknown people in the various databases we have available to us.
And so, for instance, when you are looking at, when you work on the assumption that there were two contributors, and you provided a range for these different items of evidence based on an assumption of two contributors, you don't assume that you know the identity of the two contributors, do you?
All these frequencies are for unknown contributors. They are all calculated, throwing away any idea we might have who contributed. So these are all unknown people. These numbers refer to the frequency of which we'd find that evidence if the evidence profiles were given by unknown people. Yes.
And so what you actually did in arriving at these calculations and these estimates, Dr. Weir, is that you would list all the possible pairs, all the permutations, if you will, that if two people created a particular stain, a particular profile, what possible genotypes could each of them have? Is that right?
Well, it's even more than that, of course. We have say, the simplest case, we have 4 of these bands, 4 alleles, so we know that's coming from 2 people. So I assume, well, I'm going to do a calculation as though they were given by 2 people unknown to me. One person might have these 2 bands and be African American. This other person might have those 2 bands and be Hispanic. Or one person might have the first and third bands and be Caucasian. The second person have the second and fourth bands and be African American. So you can see that there's a whole host of possibilities we have to consider. Remember that these contributors under this calculation are unknown to us. We have no idea who could possibly have contributed those mixed stains. And so we have no idea. We've got to consider all the possibilities that there are.
But setting aside for the moment that additional layer of complication, if you will, dealing with different races of the components, one of the things you did do, at least initially, is you would sum the frequencies of the different pairs of genotypes. Isn't that right?
That's correct, yes. We have all the possible ways of getting those 4 alleles.
And it was your intent when you did this, Dr. Weir, was it not, to sum up all the possible pairs? You don't want to leave any out.
It was my intent, and I certainly hope I didn't leave any out.
And would you agree, sir, that the more pairs that you include, the more common the ultimate frequency is?
That's right, yes.
So it's essential, to be fair to the defendant in any case, or to Mr. Simpson in this particular case, that you include all possible pairs. Isn't that right?
That's correct, yes.
And if you left out some pairs, then your number could be biased against Mr. Simpson. Isn't that correct?
It sounds as though you're finding that I've left one out. I hope I haven't.
Well, let me ask you a question, Dr. Weir. When were you first asked to prepare statistical estimates of mixtures in this case?
That was probably 2 weeks ago.
Well, didn't you receive a call from one of the prosecutors back in the middle of May when Robin Cotton was on the witness stand about a request to provide statistical estimates of the mixtures in this case?
Yes, that was the time. Is that more than 2 weeks ago?
It was about 5 weeks ago.
Oh, time flies.
In fact, you issued a report, preliminary report, as early as May 11th, 1995, didn't you?
Yes, that's correct. At the time Robin Cotton was testifying, the issue of mixtures came up.
Excuse me, Doctor, would you allow Mr. Neufeld to finish asking the question before you start answering?
Let's take a look at one of the tables, if you will, in the report that you submitted to the court in this case. I'm referring to page 33, Mr. Clark, which is table 24B. Can you put it up on the envelope, please? May I have it put up on the envelope, Your Honor?
Certainly. And Mr. Neufeld? 10:30. 10:30.
I think you know something. I think that's the same mistake I made last time with this same issue. All right.
Just giving you a heads up.
That's what happens when I get a little focused. I apologize, Your Honor.
Proceed.
What exhibit is it?
This is table 24B, Mrs. Robertson. Offense exhibit 408.
It's the defense exhibit, Your Honor.
It's 408. 408. Defense. I'm sorry. 10. Should be a 10 series. 1198. My mistake. Proceed. Thank you.
Now, Dr. Weir, maybe we could move to the board.
I can't read that. My eyes, I can see. He's the reason.
All right, Doctor, you have the report, your own page in front of you? Yes. All right, Mr. Neufeld.
Thank you. Now, Dr. Weir, you said that in preparation for this report that you reviewed at least the final reports of the DOJ and Cellmark Laboratories. Is that correct?
Yes, that's right.
And you also said that you made a number of phone calls, at least to Mr. Sims, to assist you in interpreting the data. Is that also correct?
To both Robin Cotton and Gary Sims.
Now, in this case, Dr. Weir, both Gary, I'm sorry, are you somewhat familiar with how DQ alpha typing is done?
Not in any great detail, no.
And that's why you had to rely on what Mr. Sims and Robin Cotton told you, is that right?
That's right, yes.
In this case, Dr. Weir, both Gary Sims and Robin Cotton testified that since there is no specific dot on the DQ alpha strip for the allele 1.2, it is concluded that it exists through inference and other dots or the absence of other dots on that strip. Have you heard about that?
Yes, I'm not completely clear of the details, but I understand that there are cases where the 1.2 may be present, but we can't tell whether it's present or not.
Well, didn't you notice, sir, on the reports that you read from DOJ, that whenever there is a mixture, and the mixture included both a 1.3 and a 4 allele, the 1.2 allele may be masked?
Well, the reports, I think, and on the boards anyway, say 1.2 possible, and I think I said yesterday that I've ignored these qualifications. If the 1.2 is listed, I've assumed that it's present.
Well, Dr. Weir, you said, I believe yesterday, that there were some instances where an allele may be, a dot may be very faint, maybe very weak, and in those situations you ignored the description of weak or faint.
No, excuse me.
Didn't you say that so yesterday?
I said nothing about dots being weak or faint.
Well, in the situation, sir, where the 1.2 allele is simply masked in a mixture by the presence of these other alleles, as has already been testified to, it's possible, is it not, that when you describe the various pairs, that you have to list the pairs as if the 1.2 allele was there, and then list the pairs as if the 1.2 allele wasn't there. Isn't that correct?
I'm not sure about that. I've assumed that it was there because on the board it was listed as being there, as possibly being there, and as I said, I've ignored the words possible or trace or whatever. So I've just taken my calculations for those 4 alleles.
Well, let me ask you this. Were you told by Gary Sims or by Robin Cotton that when we say possible 1.2 in a mixture situation, we mean that there may not be any 1.2 there at all? Didn't they tell you that?
They may have. I don't recall specifically that conversation.
So it's your position, sir, that in this particular table, for instance, that the reason you did not consider the possibility of no 1.2 allele is because whenever it's listed as possible, you included it in the calculations as if it was there.
That's what I've done, yes. I've taken every allele listed on the board as being there.
And that's your position throughout, sir?
That's what I've...
I'm sorry, objection to the form of the question.
Overruled.
I don't know if it's a position, it's what I've done.
Well, Dr. Weir, call your attention to table if I may, I call your attention to, I'd like to put up as next exhibit, Dr. Weir's table 25A and 25B.
All right, that'll be equals 1199. Excuse me, defense 1199.
You see that, Dr. Weir?
Yes, I do.
Dr. Weir, on this table, table 26A and B,
You're showing
I'm sorry, 25A and B. 25A and B.
Yes,
You see the little asterisk you have there underneath the line?
I see it, yes.
And you see where it says allele 1.2 at present would not be detected?
Yes,
Now, in this particular table, Dr. Weir, given the same results from the DOJ laboratory
yes,
as you have for table 24B, the table I just showed you, in this instance, you chose to accept the possibility that the allele, namely 1.2, which is a possible allele, could be masked and therefore not be there.
yes.
Isn't that correct, sir?
Well, I don't know what you mean. That the statement holds. Of course, all my calculations include the possibility of it being there.
And your calculations also include, in this particular table, the possibility of it not being there. Isn't that right?
That's correct. I have a whole range of possibilities, either with it being present or not present.
So for table 25A, which were certain mixed stains on the glove, G1 and G4, you chose to include both the frequencies given the assumption that allele 1.2 is there and the assumption that allele 1.2 is not there. Isn't that correct, sir?
That looks like right, yes.
Whereas in the table, and by the way, as a result of taking that approach, sir, in table 25A, how many different pairs did you have to sum up for the DQ alpha type?
It looks like 18.
And just so the jury can be clear on this as well, are the lists of pairs that you summed up reflected along this first column?
Those two columns.
Right. Well, it's a pair. This would be the first person, and this would be the genotype of the second person, correct?
That's right.
And so you have 18 different frequencies that you sum up on this particular table for those particular items. Isn't that correct?
That's correct.
And you did that in a situation where there is a possible 1.2 allele which may or may not actually be there because of the masking phenomena. Isn't that correct?
That's correct.
Now, going back, sir, to table 24A,
1198.
exhibit 1198, again, the same, it being a mixture. Is that correct, sir?
That's a mixture, yes.
And consequently, the 1.2 allele in that particular mixture may actually be there or may actually not be there. Isn't that correct?
That's correct.
But this time, sir, unlike the other items on the glove, you chose not to include the frequencies of those pairs, assuming the 1.2 allele wasn't there. Isn't that correct?
I think you found my mistake, Mr. Neufeld.
Well, let's talk about what that mistake means, sir. In this particular instance, Dr. Ware, your calculations are based only on summing frequencies for 6 pairs. Is that right?
That's right.
And would you agree, sir, that if you sum the frequencies for an additional dozen pairs, which would be 3 times as many as you started off with, you would arrive at a probability for that mixture which would be much more helpful to Mr. Simpson. Isn't that correct?
I might question the word much. It depends on the frequency of the 1.2 alleles.
Well-
It's kind of interesting that the frequencies in both these tables are comparable in magnitude.
Sir, would you agree, and didn't you say a little while ago in cross-examination, that if you add additional pairs of frequencies, you will arrive at a frequency that is more common than if you add fewer pairs of frequencies?
That's correct.
I'm sorry, objection. I think counsel's arguing the witness.
Full rule.
And sir, on the exhibit, a moment.
All right, Mr. Scheck, you've put up which exhibit?
272B, the glove frequency board.
Thank you. Mr. Neufeld.
Sir, in the table in which you actually did the additional calculations, for the glove items G1 and G4,
Referring to table 25D. Defense 1199.
on item G1 is a stain on the glove where it is not suggested that Mr. Simpson could be a contributor. Isn't that correct?
I believe he's listed as not, that's right, he is not listed as not excluded. I
So
think that's
he's not considered a possible contributor there. Is that right? He's not listed in the not excluded category.
Can we agree that he's excluded?
Right. And he's also excluded on G4, is he not?
Yes, the profiles are the same.
Right. And so, on your calculations, for those stains, kind of mixtures, where Mr. Simpson is excluded, you've summed up additional pairs to, which would make the frequency somewhat more common. Is that correct?
I've summed the table 25B is correct. It looks to me as though table 24B is incorrect.
And sir, not only is table 24,
When I do calculations, I do not consider any forensic implications, and if you're suggesting that I do, I will disabuse you of that right now.
Dr. Weir, you also,
Certainly.
I'd like to also look at table 24A. One moment, Your Honor. Now, unlike the items of evidence where you did sum up the additional pairs, sir, table 24A reflects items 303, 304, and 305 in the Bronco. Is that correct?
That's correct.
And
All right, Peoples 260.
Yes.
Mr. Neufeld.
thank you. And Dr. Weir, for items 303, 304, and 305, on the console, Mr. Simpson cannot be excluded. Is that correct?
That's correct.
And the calculations you did for the frequency of the mixtures for those stains fail to include the additional pairings. Isn't that correct?
That's correct, yes.
And by failing to include the additional pairings in these samples and these items, which do not exclude Mr. Simpson, the numbers that are arrived at by you and put on that board are biased against Mr. Simpson. Isn't that correct?
As it turns out, it looks that way, yes.
And sir, would you agree that you made this same error, which is biased against Mr. Simpson, not only on items 303, 304, and 305, but also on item 31 in the Bronco?
I don't know.
Would you please look at your notes?
Help me with the page number.
Would you please look at page 32, table 23A and B?
Object. Counsel's arguing to the witness at this point.
Oh, Mr. Neufeld.
Am I right, sir, that not only did you make the same mistake, which has the effect of being biased against Mr. Simpson, for items 303, 304, and 305, but also as to item 31?
Well, this item assumes that all the alleles listed on the board are present, and I've made calculations accordingly.
Well, but of course, as you know from what you did on that other item, sir, on the glove, you know that you can't necessarily make that assumption, that you had to assume it's either there and then assume that it's not there to consider the other pairs of frequencies. Isn't that correct?
Oh,
On item 31, I do not see the word possible, so I conclude that it is present.
Were you told about how the system functions, though, because of this masking phenomena?
All my analyses are based on the reported profiles, whether or not they match, and their details. I have generally ignored, although apparently sometimes I didn't, but in this case there is no suggestion that the 2.1 allele is not there, so I assumed it was there.
Sir, but isn't it, when you put on your own report with respect to other items, both on table 25A and again on table 26A, you care to look at 26A as well.
I believe in those items the word possible was listed on the board. That on item 31 it is not listed as being possible, so I assume the allele is present.
Well, when you put that asterisk on your report, before you did that, sir, did you ask either Gary Sims or Robin Cotton, what's this thing about the 1.2 allele that it's sometimes masked and sometimes isn't, before you decided to put in that asterisk and make those different computations?
No, I didn't decide to put in the asterisk arbitrarily. I think I put it in where the possible, my intention was, at least it was in my original report back in May, to assume it was either present or absent in those cases where the word possible was written. The
So
word
you-
possible is not written
Sorry.
in item 31.
And so you're saying that the reason you didn't do it on table 23A is because the word possible wasn't written in next to the 1.2 allele?
That's the only reason that would be consistent with what I did. And I assume that's my reasoning at that time.
Well, now, when you say you assume that reason, do you know that to be true, or are you guessing on that?
Well, I'm saying it's true. I can't think of every thought process I've had over the last several weeks, but that would, thinking about it now and the way I do operate, I'm sure that's what I did.
Well, Dr. Ware, now I'd like to show you table 23A. Exhibit 1200. And I'll move the board. Now, can you see, Dr. Ware, that for this particular table, you were computing the frequencies of the mixture, both for item 31, and I believe also for one of the glove stains. Is that correct?
Yes, they have the same profiles.
And is that what the sentence says at the very top there, sir, at the top of the table?
Yes, it says items 31 and G10.
And, sir, on the report that you received from the Department of Justice with respect to item G10, which you have in front of you, I hope, sir. Do you have that report?
No, I don't. No, I should say I've based my calculations on these charts in the final reports.
Sir, did you tell us a little while ago that you actually reviewed the final reports of the Department of Justice in Selmar?
Yes, those statements are not inconsistent. I certainly reviewed them. I don't have them in front of me. All I'm saying is that after having reviewed the reports, when I came to sit down and type in entries into the program to do these mixture calculations, I relied on these charts.
all right, would this be a good spot?
Just one last question. Isn't it a fact, sir, that with respect to the report from DOJ regarding saying G10 on the glove, which also is listed as not excluding Mr. Simpson, that report from DOJ told you specifically that the 1.2 allele was just possible. Isn't that correct?
I'm going to look at the chart. That's correct.
So here again, Dr. Ware, you did the same calculation for G10 on the glove, stating that allegedly cannot exclude Mr. Simpson, even though you knew that the 1.2 allele was simply a possible allele. You did the same calculations, which, as it turns out, are biased against Mr. Simpson. Isn't that correct?
Form of the question.
Sustained.
Isn't it correct, sir, that in your calculations for G10, you only sum the frequencies of 6 pairs of genotypes?
That's the way I've reported it. In fact, I didn't do any calculations on G10. I just lumped them in with the 31.
But your report, sir, says this is the correct data for item 31 in G10, does it not?
That's what it implies, yes.
And in fact, the correct way to do G10, if the 1.2 allele is simply possible, is to have the additional 12 pairs that you had on those items where you consider the 1.2 allele as possible. Isn't that correct, sir?
That's certainly true.
We can break that.
All right, ladies and gentlemen, we're going to take our mid-morning break. Please remember all my admonitions to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you. And we'll stand in recess for 15 minutes. Dr. Weir, you can sit down. All right, back on the record in the Simpson matter. All necessary parties are again present. Deputy McNair, let's have the jurors, please.
Really, Judge? Really? I sit down and you're going to do this? I'm sick of this, Judge. There we go.
All right, good morning again, Doctor. Mr. Neufeld, you may continue with your cross-examination.
Anyway, we get his accent. We get to hear his accent. There's that.
And Mr. Neufeld, this is... I'm sorry, Ms. Harris? 272B.
Good morning, Mr. Josh.
And I think you
Why were
said,
you
Dr.
hanging
Weir,
on my curtain
that
again?
your
Why?
reduced Xerox copy of the exhibit boards is identical to the large boards that we have here in court. Is that correct?
Yes, that's right.
And so, sir, even on your reduced exhibit board that you relied upon when you wrote these tables, on your copy, sir, for item G10, it says on your copy a possible 1.2 allele, correct?
Yes,
Okay, so you had that information available to you when you prepared these tables. Is that right?
that's right.
And, sir, these same biased mistakes that you made for these particular items that we've just described.
Counsel, would you rephrase that question, please?
Sure. The same mistakes you made in your calculations and computations for items 303, 304, 305, 31, and G10, those mistakes apply to your calculations for your two-donor theory. Is that correct?
Objection assumes facts on evidence as phrased.
Overruled.
I should probably clarify what we're talking about. We're talking about calculations involving DQ alpha on the mixed stains. If there was a possibility of there being a 1.2 and it's not seen, so we don't know whether it's present or not present, then the calculation should include both those possibilities for all my calculations. And if I did not include them, then I'm sincerely sorry.
Well-
And I'm also embarrassed, and I haven't finished. The DQ alpha results are, of course, part of the profile frequencies I report. They are an important part. I'm not going to minimize that. They are not the most important part in the sense that their frequencies are not the most discriminating.
Dr. Weir, the same mistake that you made on each of those items for your two-donor calculations also applies to all of your three-donor calculations for the same items. Is that correct, sir?
I think I just said that all my calculations involving DQ alpha on the mixed stains, if there was a possibility of 1.2 and not be seen, should have included both the possibilities. If I did not, then it was an error.
And in each of the instances, sir, where you made that error, those were items where, according to the prosecution, Mr. Simpson's profile could not be excluded. Is that correct?
I don't know that.
Would you care to look at the board or your smaller versions of the boards to confirm
Well-
that for each of those 5 items, Mr. Simpson is listed in the not excluded category?
Well, let's go through them one at a time. I forget which ones they are.
303, 304, and 305, the Bronco console.
That's correct.
Item 31 on the Bronco console.
Well, I thought that we had said that I was 31. There was a definite call that the 1.2 allele was present.
Well, assume for the moment, sir, that based on the testimony of both Dr. Cotton and Mr. Sims, that whenever you have a mixture and you see the 1.3 and the 4 alleles, that you don't know whether the 1.2 is there or not there. Would the same mistake apply to item 31?
Objection assumes facts and not in evidence, misstates the evidence.
Sustained. Phrase question.
Assume for the moment, sir, that if you have a mixture, as you have in item 31, where you see the 1.1, the 1.3, and the 4 alleles, that given the nature of the system, one cannot tell whether the 1.2 allele is there or not there.
Objection misstates the evidence.
Call roll.
My calculations on item 31 are with the alleles that were stated to be present, and 1.2 is stated to be present.
So what I'm asking you, sir, is I'd like you to assume for the purposes of this hypothetical that in a mixture where the 1.1, 1.3, and 4 alleles are actually present, that the examiner can't tell whether the 1.2 allele is there or not. In that situation, sir, would the same mistake be made in your calculations on item 31 as for the other items that we just described?
Objection improper hypothetical.
Call roll.
If we're uncertain about whether the allele is present or not, then it should have been included in the calculations.
Okay. And item 31 is another item where, according to the prosecution's exhibit, Mr. Simpson's profile is not excluded. Is that correct?
Mr. Simpson is not excluded, however, that had nothing to do with my calculations.
And, sir, on G10, the glove item, the final item in this group, Mr. Simpson is included in that group as well, is he not?
He is not excluded. That's correct, not excluded. Yes.
Now, in this case, Dr. Weir, for every stain that is a mixture, there could possibly be 2 contributors, correct? Excuse me?
I was thinking
Oh.
that what we know from the Wiener mixer is that there's more than one contributor. So, yes, there may possibly be 2 contributors.
And there may possibly be 3?
There may possibly be 3, although it's less likely given the evidence we see in the profile.
And there may possibly be 4?
We are talking about increasingly unlikely possibilities.
But there's no way to state with any certainty how many contributors there are, isn't that correct?
If we don't know the contributors to any stain in the whole case, if we don't know who contributed, we don't know who contributed, period.
Well, it's not just a question of who, but as to the mixtures, one cannot state with any degree of certainty how many contributors there are. Isn't that correct?
That's just what I said. We don't know who contributed, period. We don't know how many they were, who they were, what their ethnic background. We don't know who they were, period.
Now let's look at item 29, if you would.
Mr. Harris. Thank you.
Now, in your approach that you offered this jury yesterday afternoon and this morning, sir, you provided a range of frequencies based on different assumptions. Is that correct? For the mixtures.
We provided some frequencies of those mixers were given by different numbers of contributors.
And they are based on assumptions, so is that correct?
I'm not sure I understand. All the calculations assume a lot of things like independence.
And they also assume the number...
Yes.
Sorry, I thought he was. I apologize, Dr. Weir.
I forget.
Would you like to say something else, sir?
I believe not.
Sanctions.
They also assume in some of these calculations that there are 2 donors as opposed to 3. Is that right?
Well, that's not, I wouldn't say that was an assumption. Those are the frequencies.
All of my children were from one donor.
If there were 2 contributors, or if there were 3, or if there were 4. There's no assumption being
kinda
made.
rare
That's just the result
nowadays.
when there were that number of contributors.
And obviously, according to your approach, the number changes depending upon how many contributors you start off with. Isn't that right?
Oh, I think we've demonstrated that.
Now, are you familiar with the report entitled DNA Technology and Forensic Science, published by the National Research Council of the National Academy of Science?
Yes, sir.
In fact, you're not just familiar with it, sir, you actually testified before that committee that authored this book. Isn't that correct?
That's true.
And you made submissions of data to that committee that authored this book, did you not?
Not quite. I provided them with a pre-publication copy of my paper, which subsequently published on the FBI's data. So the committee was aware of my findings about independence in the FBI's data. And in fact, in the report, they say that I had demonstrated independence of the alleles in the FBI's database.
And we'll come back to that in a little while, Dr. Weir. But right now, let me ask you this. Not only did you testify before the NRC committee and offer them a pre-publication copy of your article, but after the report came out, you actually wrote letters and other publications criticizing this report, didn't you?
Yes, I was extremely disappointed by the report and some of the aspects. It did not then and does not reflect proper scientific approaches to the statistical interpretation of forensic data.
And that's your opinion, sir, correct?
No, I'm afraid it's not. I'm here under oath to tell the truth, and I have no choice but to tell you the report contains mistakes. That is not an opinion.
Well, Dr. Weir, would you agree that there's a controversy about some of the positions taken in the NRC report?
There is
You can answer the question.
There is no controversy over the fact that there are errors in the report.
We'll come back to that in a little while, Dr. Weir. First, however, the report actually has a sentence
That is the
describing
nicest
recommending
thing I
an
could
approach
say about him.
to handling
You're right.
the interpretation
You
of
should
mixed
hear what I
statements.
really
This is
say
kind of
about
the case. Is
him.
that correct?
There is one
Comb your
sentence in the
hair.
report.
And that sentence in the report is one which you disagree with, isn't that correct?
I don't think I would say so. I have some.
If someone stopped me and said, Kathy, just tell me exactly how you feel about your ex-husband. I think Lancaster would burn down.
Confidence, after all, in the authors of that report. So I can't but think otherwise, that when they wrote that sentence, they meant to say the correct thing. It could be interpreted either way. I would give them the benefit of the doubt.
Well, Dr. Weir, you mentioned earlier, I think, on direct examination that you prepared a report in connection with this case.
That's right.
Could I call your attention, sir, to page 10 of your report?
You certainly may.
Did you include in your report the following quote, sir? Simply adding the frequencies of all possible contributors to a mixture, then in parentheses you have NRC 1992, close parentheses, ignores the essential nature of a mixture. It represents the contributions of more than one person. Did you write that in your report?
Oh, yes, I wrote that in my report. I'm just trying to think what that sentence is actually saying here. It's talking about
Well, sir, I'm
adding
sorry.
the frequency.
Your Honor, I would ask that the court
Hold-
ask the witness to be
hold on.
responsive.
The question was, did you write that, yes or no? The answer is in the record. Ask your next question.
Thank you. And would you agree, sir, that in that sentence, you are citing the National Academy report for the proposition that that in a mixed stain, one simply adds the frequencies of all possible contributors to the mixture?
That's true.
And you are saying in that sentence that you are critical of the NRC position because it ignores the essential, because in your opinion it ignores what you call an essential fact.
Could you try that sentence? I lost the train of this question.
Well, in that sentence, are you not only describing what the NRC position is, namely that it calls for the adding of the frequencies of all possible, that it simply adds the frequencies of all possible contributors to a mixture, but you interpret it to mean that it is simply adding the frequencies of individuals, and by doing so, it ignores, in
All
your
I heard
words,
is I need to
the
drink
essential
alcohol.
nature of a mixture.
Done.
Yes, if the NRC report doesn't, if that was the intention of the sentence, that we should add up the frequencies of single contributors, that ignores the fact that there was a mixture.
Well, when you wrote
and
this-
that would be
I'm sorry.
wrong.
Well, when you wrote this sentence in your report, sir, you didn't state it as alternatives. Well, if the NRC meant this, then I disagree with the NRC, but if they meant something else, then I agree with the NRC, did you?
I didn't write it there, but that's what I mean. That's what I think.
Sir, isn't it true that in this sentence, however, you simply state that the NRC is calling for the summing up of the individual frequencies, and that you're critical of that? Isn't that what the sentence says?
That's what the sentence says, but I think what I think, what I believe is that if the sentence means, as I state there, single contributors, then it's not right. If we could interpret it kindly to mean multiple contributors, then it would be appropriate to add the frequencies. And I'm sorry if my language is as imprecise as the NRC's report.
Now, Dr. Weir, in your report, I call your attention to table 30, please. Found on page 39. And also table 29C on the previous page.
I have them.
Okay. According to your report, you come up with 30 different possible frequencies for item 29, just for a 2-donor or 3-donor assumption, if you will. Is that correct?
Oh, I'm not sure. We need to look. If there are two contributors to the mixed item, and I'm using 4 databases to do these calculations. All these calculations at this point are PCR profiles, and I'm using the FBI's PCR databases, and there are 4 of them. I don't know, I couldn't know who these unknown contributors could be. I'm going to assign them frequencies from the data I have available, which is the FBI's, and there are 4 databases. So there looks like 10 possible ways we could have pairs of contributors, and then the possible ways of getting 3 contributors is more than that, and it's probably 20. I'm not sure the exact number.
Okay. So that would mean that between those 2 alone, there's 30 different permutations, 30 different frequencies that you articulate for the meaning of the mixture. Is that correct?
Well, that's not quite right. If there's a mixture and there were 2 contributors that we don't know who they were, then there are 10 possible, well, it's not even possible scenarios, it's the 10 possible sets of data that I have. If there were 3 contributors and I have 4 databases, it looks like there are 20 combinations of the databases I could use. So I wouldn't add them together. If there were 2, I have 10 possibilities. If there were 3 contributors, I would have 20 possibilities. There's a lot of different ways of having 3 people from different groups.
If one construed the NRC method that I've just read to you and that you cite in, I'm sorry, you cite the NRC method. Let me read to you the sentence as it actually appears on page 59 of the National Research Council report, Dr. Weir.
Please do.
It says, quote, if a suspect's pattern is found within the mixed pattern, the appropriate frequency to assign such a, quote, match, unquote, is the sum of the frequencies of all genotypes that are contained within, that is, that are a subset of the mixed pattern. You're familiar with that sentence?
Yes, I am.
Okay. Now, if the NRC meant by that you simply add up the genotypes of all the different individuals who could possibly contribute to that, that would be the reason that you were critical of it in your report. Is that correct, sir?
If they meant to add up the frequencies of single people, they would be wrong. It would be very misleading to do that as an interpretation of a mixed stain. So I would be very critical.
Doctor, could you pull the microphone closer to you, please? Thank you.
Well, let me ask you a simple question, I hope, sir.
Thank you.
For item 29, according to Cellmark, they see 3 DQ alpha alleles, correct?
They report a 1.1, a 1.2, and a 4.
Okay. And you would agree, sir, that Mr. Simpson's profile on the reference sample is a 1.1, 1.2. Is that correct?
That's right, yes.
And so he cannot be excluded.
He cannot be excluded.
And you would also agree that Nicole Brown Simpson's profile is a 1.1, 1.1, correct?
Yes, that's correct.
And she can't be excluded.
On the basis of the DQ alpha typing from Cellmark alone, she could not be excluded.
Well, she also could not be excluded on the basis of the polymarker typing as well. Isn't that correct?
I'm not sure. I'd have to look at the details.
Well, do you have that report handy?
Yes, and I'm just, this is item, I need to be careful. This is item 29, the
Yes.
polymarker from Cellmark. There are 5 of these loci, and the mixture has, at LDLR, it has alleles A and B, and Nicole Brown has an A and a B, so she's not excluded. GYPA has A and B, as does Nicole Brown. She's not excluded. HBGG has an A, a B, and a C. Nicole Brown has an A and a B, not excluded. D7S8 has an A and a B in the mixture, and also Nicole Brown is AB, not excluded. And GC, the mixture has an A, a B, and a C, and Nicole Brown has an AC, so she's not excluded on any of those systems.
And neither is Mr. Simpson, isn't that correct?
Mr. Simpson's profile is not the same, but he's also not excluded.
So the one allele in this mixture, which neither Mr. Simpson or Nicole Brown Simpson can account for, is the number 4 allele, correct?
Well, now we have switched, have we, to the DOJ's PCR determination.
No, I'm looking at Cellmark's.
Oh, excuse me. The DQ alpha, the allele 4, that's right. That's not contained in those profiles of Simpson or Brown.
Okay, and you also know, and I think you stated in your report, and Dr. Codman has already testified in this case, that Mr. Goldman is excluded from being a contributor to this stain as well.
Yes,
Is that correct?
Mr. Goldman has a 1.3, which is not seen in the mixture, so he was excluded.
So the question, sir, is who contributed the number 4 allele? And what I want you to do, Dr. Weir, is simply answer one question for me. Is there a method that you can utilize to determine what percentage of the population could contribute the 4 allele to this mixture? Can that question be answered?
It can be answered, but I wouldn't answer it in this context. I mean, I wouldn't do that calculation because it would have
Your
no
Honor, I
bearing.
asked that you instructed witness to be responsive. The question simply asked him,
No.
can he do it?
He's entitled to explain his answer, counsel.
I would not do such a calculation to interpret a mixture. These mixture stains are not really any different from the other ones. They are profiles of DNA, and they have various characteristics. The point of what we're doing is to try and say, how likely would we see that profile if the prosecution's story was correct and they say they know who contributed, then what we see is as we would expect. If we know who the contributors were and we see their profiles, then we don't have any surprises.
Next question.
So what I want to ask you to do, I'm sorry, can you, though, do the calculations that I simply requested?
I can, but I wouldn't.
When you say you wouldn't, you mean they're not the ones that you think are appropriate. Is that correct, sir?
No, they are not appropriate.
Well, sir, the question that I'm asking you is the very question or the very methods described in the NRC report, which in your report you state that you disagree with. Isn't that correct?
No, I think I follow that statement. If the NRC is recommending add up for single contributors, then I disagree because it's wrong.
And now I want you to follow, for this jury, if you would, the approach described in the NRC report, which you think is wrong, just so we can provide this jury with some other frequencies.
Rephrase the question.
What I would like you to do, sir, is using the data that was available to Cellmark in this case, I would like you to calculate the frequencies of all people in the population who have the potential of contributing the number 4 allele to this mixture. And what I'd like you to rely on, sir, in doing your calculations, what's next in 1201? It has to be marked as defendants 1201. I've shown a copy of it too.
Is this the FBI database?
No, Cellmark.
Somewhere. All right.
Showing the witness 1201. You said you've worked with Cellmark over the years, sir?
Yes.
You're a consultant to Cellmark?
No, I'm not a consultant with them. Our university has a contract with them.
And the university has a contract to do consultant work for Cellmark?
The university has a contractual arrangement to undertake data analyses. I don't think that's a consultancy.
Dr. Weir, have you ever seen this database before that I put before you?
This is not a database. This is a list of frequencies, and I have seen it, yes.
I'm sorry, okay. And this is, as you know, the frequencies in the frequency table that Cellmark says it uses when it does its calculations for DQ alpha profiles. Is that correct?
Yes, that's true.
All right. Now, actually, what I'd like to do, sir, is ask you one preliminary question before we get to the question about the 4 allele. And that question is, sir, what I'd like you to calculate is the percentage of the population that cannot be excluded as contributing to this mixture. Okay? That's a very different question than the question that you answered before to the jury, but it's a question I'd like you to answer using that database.
I'm very uncomfortable in doing any calculations I know to be wrong and not relevant to this data.
I
don't feel comfortable at all using my reputation to give credence to some numbers which I don't believe should be calculated.
I appreciate that, sir, but I'm going to ask you to just simply answer my questions.
And I'll repeat my objection to doing so. I will do so if instructed, but I object very strongly.
I'm going to enter objection under 352 based on this evidence as misleading and confusing, based on the evidence before the court and jury as well as irrelevant.
Your Honor, it's a speaking objection.
It is. Sidebar. Court reporter, please. Thank you, counsel. Proceed.
Thank you. Now, I understand that you said that you disagree with this approach, but I'm simply asking you to do certain calculations, or make certain calculations to answer this question, which is, what percentage of the population could be included as a contributor to this profile, namely the 1.1, 1.2, and 4 alleles that you see on the steering wheel? And what I'd like you to do, sir...
Excuse me, the original question was excluded, so we're now talking about included. Is that correct?
No, that percentage of the population that cannot be excluded, which would be the same, I believe, as that percentage of the population which could be included. Is that correct?
I think so, yes.
All right. And as you know, it is Selmark's approach, when it looks at those different frequencies, it takes the highest frequency from the different databases. Is that correct?
Yes, they have, for Caucasians, they have 3 data sets they rely on that they have access to, and they take the highest frequency for each allele. But,
Okay.
excuse me, here this table is of pairs of the genotypes, the pairs of alleles.
I'd like to put the table up as Exhibit 1202.
All right, 1202. Do you have a copy for Dr. Weir?
I'm sorry, what?
Do you have a copy for Dr. Weir, since it's hard to see some of the detail?
Certainly. Finish 1201.
1201 or 1202?
Or 1202, I apologize, Sean. Here's my copy. Yeah. Now, looking at this table, sir, is it clear that the...
Certainly.
And so to get a mixture, it would require the contributions of different individuals, would it not, sir?
The mixture would require the contributions of more than one person, that's right.
And by that you mean by different individuals, is that correct, sir?
Yes, yes, I do.
Okay, so now what I'd like you to do is to look at the individual genotype frequencies of those individuals who could contribute to this mixture.
I don't think I can do that from this chart. I don't see the frequencies of the pairs of individuals who could have contributed.
Sir, I'm asking you to calculate. I understand how you disagree with this approach. I'm simply asking you to calculate the individual frequencies. And my first question, sir, is, according to the chart that you have, are there frequencies listed in the Selmark table for the genotype frequency for the 1.1, 1.1 genotype?
Yes, there are.
And what frequency do they give?
Well, Selmark lists the 1.9%.
Okay, and do they also list a frequency for their African American database?
Oh, yes. Yes, that's 2.3%,
And do they also list one for their Hispanic database?
and that is 16%.
And then do they also have the genotype frequencies for the second genotype, 1.1, 1.2?
Yes, they do.
And just to save some time, are the numbers that I have on that table consistent with the numbers that you have on the Selmark table?
Referring to 1202 and 1201, respectively.
The numbers on the shorter table are an extraction of the numbers on the bigger table, yes.
There's nothing inaccurate in my writing down or recording the numbers on Defendant's Exhibit 1202, is that correct?
I don't see any. I'm sure they're correct.
Okay. And can you think of any other genotypes of individuals who could contribute to the mixture on the steering wheel other than the 6 genotypes that I've listed on the table?
Well, the contributors to the mixture, of course, are a mixture of people. There is no single genotype not listed here that did not contribute. Did I get that right? I think the answer is yes.
Okay. Yes, there are no others other than what's listed here. Is that correct?
Yes, sir.
Okay. And, sir, if you now sum up the frequencies of individual frequencies who could contribute to this mixture, first using the Caucasian database that Selmark relies upon, is the number 45.4% an accurate number of the summation of those frequencies?
I'm not going to check that. I'll assume that it's accurate.
Okay. And is the number 59.2% reflect the sum of the frequencies of individuals who could contribute to this mixture in Selmark's African American database or table that they rely on?
Yes, those numbers are probably sum to 59%.
And is the frequency 48.8% of the population the number that one would arrive at relying on Selmark's Hispanic database?
That's true.
Now, sir, what I'd like you to do is go back to the question that I initially posed and then walked away from, which is what percentage of the population could contribute that number 4 allele that we know that neither Mr. Simpson could contribute nor Nicole Simpson Brown could contribute, and we know Ron Goldman is also excluded. And I want to ask you just about that one now. Did you have another copy? Oh, no. You're on. This next slide be marked as Defendant's 1203, and I'll offer you a miniature copy of it, Dr. Weir, to assist you.
Thank you. Thank you.
Now, Dr. Weir, again, what I want you to do is to rely on the cell mark tables. And just looking at the possible genotypes that could contribute the number 4 allele, is this slide correct in saying that the 3 possible genotypes are the 1.14, the 1.1, I'm sorry, let me start all over again. Would you agree, sir, with this table that the genotypes of individuals who could contribute the 4 allele to this mixture on the steering wheel would be somebody who has either a 1.14 genotype, somebody who has a 1.24 genotype, or somebody who has a 4,4 genotype?
Yes, if the person was a contributor to the mixture, they must, and they gave a 4, they must have a 4, and they must not have anything other than we see in the mixture, so that's correct.
Okay. And again, looking and relying on the cell mark tables in front of you, sir, are the frequencies that I have here for somebody who has a 1.14 genotype correct for the 3 different databases, namely 9.5%, 7.7%, and 9.9% of the population?
Well, they're in a different order. They're in a different order from what's on the chart, but at least I think they're correct. Yes, I think they are.
Okay. And are the frequencies from the 3 different cell mark databases for somebody who has the 1.2,4 genotype correct in the slide on the board?
The 3 numbers are there in a different order, yes.
All right. And finally, the frequencies for somebody who has a 4,4 genotype. Are the 3 numbers up there the correct population frequencies for that particular genotype in the 3 different cell mark databases?
Yes.
Now, like the next slide, which will be 1204. Dr. Weir, you already have that before you.
I can't read that small. I'll go from the screen.
Okay, fine. And sir, if you simply sum the frequencies for the various genotypes, as is shown in this slide, according to Cellmark's database, would you agree, sir, that 40% of the approximately 40% of the African American population, according to Cellmark's database, of course, has a genotype which is consistent with being a part of this mixture?
I think that's right. 40% is the sum of all the individual people who have one of their alleles of type 4.
And sir, would you agree that, again, using the same Cellmark tables, that approximately 31% of the Caucasian population, based, of course, on their Caucasian database, also could not be excluded as a possible contributor to this mixture?
That's right.
And finally, given Cellmark's Hispanic database, that approximately 38.4% of the population could not be excluded as being a contributor of that 4 allele.
Well, I do have to accompany my response by saying that that's correct, but I don't think it has any bearing on the interpretation of a mixture.
I appreciate that. Now, Dr. Weir, during your direct examination, you defended or supported, shall we say, Cellmark's and DOJ's use of the product rule to generate the frequencies in this case. Is that correct?
That's right, yes.
Would you agree, sir, that within the fields of statistics and population genetics, there has been controversy regarding the appropriateness of the product rule as it is used, for instance, by Dr. Cotton and Mr. Sims in this case?
You'll have to be more specific. I'm not sure exactly what you're meaning. A lot of people said a lot of different things. I don't You started talking about independence and then you started talking about controversy, so I need to understand what you're asking me.
Well, has there been controversy about the methodologies used by laboratories such as Cellmark and DOJ to calculate the rareness of a particular DNA profile over multiple loci?
Well, I'm not sure that I can answer that very clearly. There are published ways validating the procedures used. Some people have made statements critical, but the various statements are all over the board, so we need to be focused on what specific aspect you're talking about. We can discuss that in some detail.
Well, let me ask you this, Dr. Ware. Did you testify yesterday morning at a hearing in this courtroom prior to your testifying before the jury?
Yes, I did.
And when you testified at that hearing, didn't you say that you wrote letters to different publications because you believed that the way those publications covered the debate on these issues was one-sided? Did you say that yesterday?
Yes, I said that.
Okay. So when you said there was a debate, you meant that there was a debate within the scientific community, did you not?
Not quite. There was a debate, and I would classify that debate as being almost in the popular press. That wasn't a scientific literature debate. So I want to be clear about that. I have written letters to the editors of journals that have essentially carried news stories about this forensic uses of DNA. That's different from the scientific literature.
But you were referring to a debate when you gave that testimony yesterday.
The debate was the debate was not in the scientific literature.
Well, Dr. Ware, you said that you are familiar with the National Academy of Science NRC report, correct?
Yes, I am.
And this report was authored by a committee of distinguished scientists and forensic scientists and others. Is that correct, sir?
That's certainly correct.
And you would agree the National Academy of Science, which is responsible for this undertaking, is an extremely prestigious scientific organization in this country. Is that
Yes.
a fair statement?
Yes, it's a very prestigious organization.
Would it perhaps be the most prestigious organization in this country?
I think that's a fair statement.
And this report represents the National Academy of Sciences National Research Council's effort to address the various issues involved in DNA technology and forensic science. Is that correct?
Yes, it's a report set up by that body and actually conducted by a committee of members outside that body, but it's under their aegis. Yes.
Well, the chairman of this committee was Dr. Victor McCusick. Is that correct?
Yes, it was.
And you're familiar with Dr. McCusick's reputation, are you not?
Yes, I am.
He's an extremely distinguished scientist, is he not?
Yes, he is.
And he's an extremely highly regarded geneticist, is he not?
Yes.
In fact, Dr. McCusick, who's the chairman of this committee that authored this book, is a member of the National Academy of Science, isn't he?
Yes, he is.
By the way, are you a member of the National Academy, sir?
No, I'm not.
Now, aside from Dr. McCusick, Dr. Ware, there were other very highly regarded geneticists on this committee. Is that correct?
Yes, certainly.
And there are also highly regarded forensic scientists on this committee. Is that correct?
Well, I assume so. I'm not familiar with that field so much, but I assume they're reputable and highly regarded.
Well, you've attended some of the meetings within the forensic community over the last few years, haven't you? And given talks?
Yes.
Given-
All I'm saying is I'm not as familiar with those people, but I understand that they're very good.
Well, do you know who Paul Ferrara is, for instance?
Yes, I have met him.
And do you know him as the head of the Virginia Division of Forensic Science?
Yes, I do.
And based on what you know of him and what you've heard in the community, does he have a very distinguished reputation
Yes, certainly.
in the forensic science community?
Yes, certainly.
And he also sat on this NRC committee, did he not?
Yes.
And Dr. Hay Kazazian, do you know who he is, sir?
Yes, I do.
And is Dr. Hay Kazazian a very distinguished geneticist in this country?
Oh, certainly.
And he too sat on this committee that authored this report, correct?
Yes.
And then we come to Dr. Mary Claire King. She was another member of the committee that authored this report, and she too a very distinguished geneticist.
Yes.
And in fact, in the document which you've read, they describe Dr. King's expertise is in the area of genetics as well as population genetics. Are you aware of that?
Yes, I believe that's what it states, yes. And it's a true statement.
And also included in the same group is Dr. Eric Lander. Is that correct?
Yes, Dr. Lander and Dr. McCusick and I have a bond in common, of course, because we were on the subsequent NRC committee to examine some of these issues.
Well, when you say the subsequent NRC committee,
The subsequent
you're not on the committee that's asked to draft another report. You were on a committee that considered the propriety of setting up a second committee. Is that correct?
We were on the committee that unanimously recommended a new report be issued to clarify some of the problems with the present report, yes.
And was Elizabeth Thompson also on that committee?
Yes, she was.
And you're aware that she disagrees with you on some of these issues, aren't you?
Oh, no. Oh, no, I'm certainly not.
How about, was there a Dr. Zabel, who was also on that committee?
I don't remember Dr. Zabel being there, but I've seen his name, so obviously he was there, yes.
And are you aware of the fact that Dr. Zabel also disagrees with your positions on some of these issues of the correct statistical approach to interpreting DNA evidence?
Sustained.
And is Dr. Landner a very distinguished member of the scientific community?
Dr. Lander and I think, are in agreement on the need for a new committee. He is very
Excuse me,
distinguished.
sir.
Yes.
Your Honor, I would ask the witness to be responsive.
Enter the question, Doctor.
Is he a distinguished member of the scientific community?
Certainly, Dr. Lander is a very good scientist.
And Dr. Henry Lee was also on that committee. Are you aware of Dr. Henry Lee's reputation in the forensic science community?
Only vaguely. I've seen his name in the newspapers.
And Professor Dr. Richard Lempert was on that committee as well, correct?
Yes, I know Dr. Lambert now quite well.
And he's an expert in the field of statistical inferences in evidence, is he not?
Yes, he and I share our common belief in the correct way to interpret these evidence.
We'll get to that a little bit later, Dr. Weir. And Dr. George Sensabar was also on this committee, correct?
Yes,
And he's also a very highly regarded member of the forensic science community, is that correct?
yes.
And Dr. Thomas Marr is also a scientist who sat on this committee as well, right?
Yes, I don't know Dr. Mara. I know his name's listed, but I don't know him.
Well, as not only you know his name, but you know his reputation as a leading geneticist.
I must confess I don't in any detail.
Right. Now, this book, authored by the NRC committee and authored by the individuals who I just listed to you, states, does it not, that there is a substantial
Objection calls for hearsay, Your Honor.
Sustained.
So in your report, do you cite the NRC report?
I listed, but my report does not depend in any way on the NRC report.
Have you considered the NRC report in reaching your positions on the appropriateness of using certain statistical methods for interpreting DNA evidence?
Certainly not.
You haven't considered it?
Certainly not.
Have you in fact written papers and articles or letters to people criticizing positions taken in the NRC report?
Yes, I have.
Now, I'm not asking you, sir, at this point about the correctness of what the NRC did. I'm simply asking you whether or not the NRC recognized a controversy in the...
Objection, hearsay, Your Honor.
Overruled. Controversy in what particular area, counsel?
Yes, Your Honor. Simply asking you, sir, not whether you agree or disagree with the NRC's position, but did the NRC report acknowledge that there is a substantial controversy has arisen concerning the methods for estimating the population frequencies of specific DNA typing patterns?
Overruled.
That misleading statement is in the report.
But it is in the report.
That misleading statement is in the report.
And it is the position expressed in writing by the authors who we just described.
Well, I'm not sure it's the opinion of all the authors on that report.
But did I quote the report accurately?
I'm sure you did.
And I believe you said that you made formal submissions to the NRC committee. Is that right? That authored this report.
Yes, you and I were in the room at the same time when I spoke to the committee.
And at that point in time, you didn't say to yourself, Dr. Weir, I'm not going to make a presentation of them because these people don't know what they're talking about, did you?
Oh, no, I was very excited about this committee. I thought it was a group of fine scientists and that we might get a document to guide us in the future. I was very pleased to be there.
But you didn't like the final product that was turned out, did you?
No, I don't.
And in fact, the NRC chose to reject your opinion as to the appropriateness of the then current methods for estimating those population frequencies, didn't they?
Sustained.
Well, Dr. Weir, did you feel resentment about the fact that the NRC report reached a different conclusion than the one you would have wanted?
Overruled.
Well, I'm not sure there's no single conclusion in the document. Could you tell me which one you're referring to?
Fine. This conclusion, quote, although mindful of the controversy, the committee has chosen to assume for the sake of discussion that...
Sustained. Let me see counsel sidebar. Which one is this?
final.
Proceed.
Dr. Weir, did you resent the fact that the National Academy of Science report did not take your advice and recommendations as how to calculate population frequencies?
That's too broad, I'm sorry. If we're talking, you have to tell me exactly what we're talking about, because there are many aspects to that question.
Okay. Dr. Weir, did you resent the fact that the National Research Council came up with an approach to calculating population frequencies which gives considerable weight to the possible presence of population substructure?
Objection to the facts not in evidence.
Well, he's already testified to taking substructure into consideration in his testimony.
I agree with the need to incorporate substructure.
But did you agree with the manner that the NRC chose to incorporate substructure?
What are you talking about specifically?
Do you agree? I'm sorry. Do you resent the fact that they came up with a ceiling principle approach to handling the issue of substructure?
The ceiling. The ceiling approach is not the appropriate way to account for population substructure.
And in your testimony and in your discussions with the NRC committee, did you take a position opposed to using the ceiling approach?
No. When I had discussions with the NRC committee, it was before the ceiling approach was formulated.
Okay. Well, did you take a position that was inconsistent with utilizing the ceiling principle?
It never arose. If you recall, my testimony before the NRC committee had to deal with the use of measures of genetic distance, and I touched upon my independence testing. The concept or the issue of substructuring did not arise at that point, and I didn't address it.
Okay. So do you resent the fact that the NRC committee chose to adopt the ceiling approach to handling population frequencies?
Objection vague also.
Well,
I don't resent anything. I think the ceiling principle is the wrong way to do something. That's not resentment.
Now, I believe you said a moment ago you referred to a second NRC committee. Is that right?
Yes, I did.
And is it true, sir, that once the NRC report was published, it inspired additional controversy in the scientific community?
I don't like the word additional. The report itself generated controversy.
Well, sir, the report itself says that it was created and written because of the controversy surrounding these issues, didn't it?
I've already said that I don't believe that the report was accurate in describing a controversy. However, the book itself certainly created a controversy.
And in fact, there was sufficient controversy, I think, as you pointed out a moment ago, that a determination was made to establish a second NRC committee to reinvestigate some of these issues. Is that correct?
Yes, the NRC committee convened a panel of which I was a member, along with members of that original committee, and we recommended that they issue a new report.
And also, I guess you said that some of those other scientists who were not part of the original committee that I just mentioned, namely Dr. Thompson and Dr. Zabel, were also present at that committee meeting.
Yes, there were several others, yes.
Now, when they came time, though, to select the members for the second committee, you were not included as one of those people. Is that correct, sir?
I was excluded by the ground rules of the membership of the committee,
And do those ground rules include the fact that you were perceived as a partisan on this issue?
apparently. Partisan, yes, I had spoken out sufficiently to be perceived as having strong opinions.
And the second committee has not yet published its findings. Is that correct?
That's correct, yes.
Isn't it a fact, sir, that as recently as last November, just to give a sense of the continuing nature of this controversy, Dr. Ware, isn't it a fact that as recently as last November, 25 scientists in the fields of statistics and population genetics signed a letter asserting that the country...
Sustained.
Sir, did you receive a copy of a letter?
Sustained. We're not going into that. We broached this once before. We're not going into that letter.
On the sidebar?
Nope.
So you said earlier on direct examination that Dr. Elizabeth Thompson is somebody whose work you've actually relied upon in doing some of the tests that you've done on forensic data. Is that correct?
That's correct. I think very highly of her work, and I was pleased to be able to use it.
and you regard Elizabeth Thompson as a extremely well-regarded member of the scientific communities involving population genetics and statistics?
Yes, I do.
And are you aware that Dr. Thompson takes the position that there is...
Sustained.
Have you ever read anything signed by Dr. Thompson describing her agreements or disagreements with your positions concerning use of the product rule?
Objection calls for hearsay.
Overruled.
No.
Have you ever seen a letter authored by Dr. Elizabeth Thompson describing the extent of the controversy on this issue?
Objection calls for hearsay, also assumes facts not in evidence.
Overruled. Have you ever seen such a letter?
I don't think so. I've seen, and I'm trying to, you'll need to show me what document you're talking about, of course.
1203? Four?
1204. 1204. 1205. 1205.
An objection based on what the court has already stated.
So the question was, is he aware of any such? He can be shown the item and asked if he recognizes it.
Yes, I have seen this letter before.
And have you not only seen the letter, but you've also seen the list of signatories, correct?
Wait, over at the sidebar. Give me that.
Dr. Weir? Do you know who Dr. Marcus Feldman is?
Yes.
Objection relevant, Your Honor.
Sustained.
Dr. Weir, when other well-respected scientists in your field express a disagreement with you, does that ever affect your position on the subject?
Objection assumes facts not in evidence.
Overruled.
It would if they did, but that has not arisen.
Well, Dr. Weir, is it your position that you have read all the critical comments that have been written either in letters or in publications which disagree with your position on these issues?
Objection assumes facts not in evidence, also calls for hearsay.
Overruled.
I'm sorry, I don't understand that question at all. I have read a lot of material involved in the forensic uses of DNA, but you're asking me to make statements about people disagreeing with what I do, and I would need you to be more specific than that.
Dr. Weir, I just showed you 1205.
Sustained.
You said on direct examination, Dr. Weir, that you have only consulted or testified on behalf of the prosecution. Is that right?
That's true.
And that the only time that you have been invited to testify for the defense, you declined. Is that correct?
The only times, yes.
Now, wouldn't it be also true, sir, that you don't agree with all the methods that are used by forensic laboratories to calculate the statistical significance of a match?
You will have to tell me what you're talking about. I'm not sure what you mean.
Well, for instance, Dr. Weir, you told us that it is your approach to always put a upper confidence limit on these numbers. Is that correct?
I said that, as I said, that goes along with the product estimate, and of course I agree with the product estimate reported by these laboratories and others. I would go an additional step.
And that additional step of a confidence limit will actually make the frequency more common, will it not? As an upper limit.
No, it has no effect on the frequency, of course, but the estimate remains as it is, and then we have an upper bound on the estimate.
And the upper bound on what that estimate is a more common number, okay? It's not as rare a frequency as is the estimate itself provided by some of these forensic laboratories. Isn't that correct?
That's true. We keep both things together, but you're true. The outer limit of this interval is more common than the estimate itself.
And you also testified, sir, that you believe that there is substructure within the broader American racial groups. Did you not?
Yes, I think I said that. We certainly expect there to be genetic differences amongst groups, yes.
And that when you make your calculations in a case, that you take this further step to compensate for that substructure. Isn't that correct?
Yes, I do.
And if you take that additional step to compensate for that substructure, that also will make the frequency a more common number, not as rare an event. Is that correct?
Yes, it will, but we should say what effect it has. Putting in a realistic amount of substructuring has an effect which is almost negligible.
Well, let me ask you this, though. But both those approaches, your approach to compensating for substructure and your providing the upper confidence limit, depending on the data in a given case, that could be of some assistance to a defendant who is confronted by a laboratory that has chosen not to take either of those two steps. Isn't that correct?
Objection argumentative.
That was long. I think the estimate doesn't change. The estimate remains. The profile has a frequency estimate. That does not change. These additional steps give us some measure of how far apart we might be from the true answer. And of course, I could give a limit the other way. We're only interested in the more frequent. Now, you know as well as I do that the estimate may be a lot more rare than we report. I believe it's a lot more rare than what we report. We are giving the upper confidence limit, not because we are saying the estimate is truly bigger than reported. It could possibly be. It could possibly be a lot less.
So all I'm saying, sir, is that depending on the data in a given case, by providing the upper confidence limit, which you do in each case, and by taking that next step to compensate for substructure, those two steps can make the evidence less rare, or have the impression of being less rare. Would you agree with that?
Not quite. The estimate remains the same. We are attaching a level of precision to it, and we're only giving it in one direction. That direction makes the estimate look more frequent. It's not changing the estimate.
Fine, but you said that direction makes the evidence look more frequent. Is that
That's
correct?
the direction we've chosen to report. We could have chosen the other direction, but that would be foolish, I agree. But this, we're giving half an answer, we're giving the upper limit.
But some of the testing laboratories that testify in court to their results don't do either of those two things that you just described to give a higher frequency. Isn't that correct?
No, that's not quite correct. Cellmark gives confidence limits.
To your knowledge, did Cellmark give a confidence limit in its testimony in this case?
I'm not 100% sure, but I think in some of those reports there are confidence limits reported. I would need to go back and look.
Why don't you take a look at those reports, sir?
I can't, I'm sorry.
To your knowledge, did the Department of Justice offer confidence limits when it gave its numbers in this case?
No, they don't.
Okay. So in those situations, depending upon what the data is, if a laboratory a laboratory used by the prosecution chose not to take those two additional steps, which can create, as you just said, going in one direction, a more common frequency, then your assistance to a defendant or a defense attorney could have some importance, could it not?
Thank you. I take that point.
You agree with that?
I certainly do.
Yet, you have never, in all the years that you have been involved in this issue and testified in cases, even offered to consult without testifying to a single defense attorney on any case. Is that correct, sir?
Well, that's correct because the defense attorneys don't want me to do that.
Can we stop at this point, Your Honor? Thank you.
All right, ladies and gentlemen, we're going to take our recess at this time. Dr. Weir, you can step down. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. And do not conduct any deliberations until the matter has been submitted to you. Just for your information, we'll be in session on this case this afternoon with just the lawyers. We have 3 motions to take up, so we'll be busy while you're probably out at the movies. So enjoy the weekend, and we'll see you back. I'm going to ask you all, however, just to step back
Do
in
we
the
know
jury
what
room for a
movie
few
they're
moments. I need to
seeing
take a few
in
things with the lawyers.
1995?
Then we'll excuse you for the afternoon. All right, have a nice weekend.
Hold on, I'm not fast forwarding it, I'm Googling it. Top movie. The Usual Suspects, 7, Toy Story, Casino, Apollo 13, Sense and Sensibility,
From the court, Mr.
Braveheart.
Carpin. You said you needed to talk to the court about something?
Yes, I do, Your Honor. Your Honor, yesterday and I guess a couple of days ago, there was a statement made by Mr. Darden at sidebar regarding Mr. Simpson not taking some medication. And that statement was false. And since that time, we've had occasion to had Sean Chapman of my office talk to Dr. Johnson, the LA County Jail. And Mr. Simpson has, on every occasion, taken his medication, and the medical records at the jail verify that fact. And I want to, there's a story written about this that's totally nonsensical, medically contraindicated, and I've thought compelled as an officer of the court to indicate what the records indicate, what my client has also indicated, that he takes his medicine every day, and that he has never at any time not taken his medicine for his rheumatoid arthritis, sulfasalazine.
What does that have to do with whether he murdered Nicole and Ron? Sir, what are you talking about?
His call, and that the records at the jail so indicate that, and I think that the record should be made clear in that regard. And we took the further statement, as I said, to talk to Dr. Johnson this morning, who verifies that fact also. So I felt compelled to indicate that to the court.
All right, counsel, our agenda for this afternoon is the people's motion regarding discovery of defense expert statements. We have a people's motion to quash a subpoena upon the various district attorney personnel, and we also have a motion regarding transcripts. Is that our complete agenda for this afternoon? All right, see you all at 1:30.
Whether he takes his medicines right now, or that someone wrote a newspaper article about it or whatever, is irrelevant completely to this court case. At least they didn't spend weeks on it. Oh, Josh, you're so freaking smart. I can't believe how smart you are. That's what it is. If he wasn't taking his medicine,
matter.
he would have swollen up.
All parties are
God,
again
what an
present.
effect.
We have 3 matters to take up. A prosecution motion for additional discovery.
See, that's right.
A prosecution motion
yep.
to
So
quash
smart, you guys.
subpoenas served upon certain deputy district attorneys and district attorney employees, and a motion by the ACLU on behalf of certain press interests regarding transcripts. Let's take up the discovery motion first.
Good morning, Your Honor.
Good afternoon.
I'm sorry, good afternoon.
Good afternoon, Ms. Lewis. Time flies, huh?
I was going to say that, but I didn't think it. Well, I'll keep my opinion on whether that was warranted myself. Your Honor, we have on several occasions already appeared before this court with empty hands, empty of defense discovery, with formal motions asking the defense yet again to give up what the reciprocal discovery law tells us we have a right to. And we are here once again for that purpose. And I'm here to talk about not just experts' reports, but discovery with regard to lay witnesses as well. Now, first of all, with regard to experts' reports, this court has admonished the defense repeatedly throughout this case that it was skeptical of the lack of experts' reports, that if it discovered or it came to light that their reports either existed or that
Then
the
it
experts
is
had
very
somehow been told
relevant.
not to write reports when they otherwise would normally prepare reports, the court has repeatedly admonished the defense that severe sanctions would be imposed. Now, the defense already, for the first time, or the first most egregious time back during opening statements, failed to disclose discovery, which the court found that failure to be an intentional and flagrant violation of the discovery laws, and an intentional one, that they did that for a tactical advantage. That was back in January 30th, I think, was when the court issued its order in that regard. Even after the court at that time ordered the immediate disclosure of experts' reports, we had to come again with palms open and hands empty, asking this court to compel them to do what it already ordered they do. Now, what they did was say that there was some dispute over the extent of experts' reports, some minor issue that could have been resolved without us having to wait weeks for discovery, without getting it, and then have to bring yet another formal motion. That finally got some action on their part. Apparently, that's what caused them to go to the court in camera to determine what they had to turn over. At some point after that, we got rough notes from a number of their experts, rough notes of observations. Still no reports. Now, we're here again, Your Honor, and the court admonished the defense that the last time, I believe, was May 30th, when you told them at sidebar that if it turns out that they were in the wrong and not providing us reports, their experts would not testify. And given their demonstrated failure to abide by discovery laws on several occasions in the past, I think suspicion is warranted. And we are very suspicious. We believe that there are reports that either exist that we should be getting that we're not getting, or that their experts have been called off of writing them somehow. Now, along these lines, Your Honor, I do want to point out that the court seems to feel that there is something improper about the prosecution, and I'm not sure I'm accurate in saying this, so I want to be careful, but there seems to be something improper in the prosecution contacting defense expert witnesses. Now, once they place an expert witness on their witness list, which, for example, they had done with Dr. Reeders back in October of 1994, once they do that, the reason for doing that is that it triggers the reciprocal discovery obligations. It certainly triggers our right to contact that expert. And that's what this whole area of reciprocal discovery is about. So we feel somewhat constrained, and we're in a difficult position. Are we allowed to contact experts whose reports we have not gotten, or are we not? So long as they're on the witness list, the law I submit gives us the right to contact those experts, and we should be contacting those experts. But the defense wants to argue out of both sides of its mouth, saying that, well, we're not going to have them write reports, so we don't have reports to give you. And meantime, you're engaging in prosecutorial misconduct somehow if you try and contact those experts if at all. So they can't have it both ways, Your Honor. This is a period and a time and an age of reciprocal discovery. They cannot continue to shield their experts. There is one fatal flaw in reasoning, which the defense still insists on engaging in, and it applies not just to expert witnesses, but to civilian or lay witnesses as well. And that is, let me start by saying that once they have placed these witnesses on their witness list, they have demonstrated under the language of footnote 11 in Izazaga that it is reasonably likely that they anticipate calling those experts at trial. Now that happens as a matter of law. And once that happens, that is what triggers their discovery obligation. There have been statements made in the course of the last few months by Mr. Blazer, Mr. Scheck, and others that demonstrate apparent ignorance or an unwillingness to follow that mandate, because they still demonstrate this subjective intent idea where if they end up not calling a witness, an expert witness or any other witness at trial, then they don't have to provide discovery. But they've missed the whole point of reciprocal discovery. While the reciprocal discovery is not designed to force them to call a witness to trial, it is designed to provide the prosecution with an understanding and a full knowledge and opportunity to cross-examine intelligibly, because we have knowledge of their prior reports and what they would basically testify to. Now, they do get the final decision on whether they don't call that witness at trial, and that assumes, of course, that this court does not preclude them.
Okay, we're not reinventing a wheel. This isn't the first trial ever. So, there has to be a law already in place. If you have a witness on your list, yes, you have to provide discovery, or no, you don't. I don't understand. This isn't anything new. I don't know what the law is. But there has to already be a law in place about this. There has to be.
Because of discovery violations for making that decision. But that doesn't mean they can withhold the discovery for those experts who still to this day remain on their witness list. When it comes to experts, to this day, with the exception of a 4-page report from Dr. Gerdes, which we did get this week on Monday or Tuesday, with the exception of that, we still have not gotten a report from any of these numerous experts that they discussed in length at opening statement and have been the subject of 2 or 3 previous motions that compel their discovery.
They can't call
we still
them.
do not have those.
Now, they can't call them.
Do you feel
Done.
I need to go beyond the previous order?
I do, Your Honor. I believe at this point in time there is good cause, considering the past findings of this court and the past orders of the court with regard to discovery, to force the defense to make an affirmative showing that they are not doing something underhanded or unethical with regard to their discovery obligations, to force them to show that they are indeed complying with the law in this regard. The court's earlier finding with regard to the failure of the defense to turn over the witnesses that Mr. Cochran mentioned during opening statement indicates that they were not that they are not unwilling to engage in that kind of conduct. And that was what we started off with back in January, where they intentionally withheld, and the court made a finding that they intentionally withheld discovery on those witnesses for no good legal ethical reason, but only to gain a tactical advantage. And the court issued some strong sanctions in response to that in terms of allowing us to reopen and admonishing the jury, and those sanctions were appropriate. Now, Your Honor, I've been before this court a number of times on this issue. I've never yet before now, and I am asking now, for you to preclude them from calling any expert for whom we do not have a report, and for whom they cannot provide a satisfactory explanation that the court believes and the court gives credibility to as to why they don't have that report and whether they're getting that report and when they're going to get that report. Because it's been on the table now for months and months that these experts would normally, it's everyone's expectation that an expert writes the report. That's what everyone expects, prosecution, and I won't speak for the defense, but that is the expectation. Now, if I may, I want to mention there's a problem with regard to civilian witnesses or lay witnesses. The prosecution and the defense early on in this case had an informal agreement that we would not exchange attorneys' notes of witnesses. That agreement was not, to my knowledge, and I've looked and thought about this, it was never finalized, or formalized, I should say, with regard to the defense's obligation to provide witness statements that their attorneys took, as opposed to their investigators. Now, we, on the other hand, the prosecution did, because of global discovery demands, enter into an understanding with the defense, which we embodied in a document, which we gave the court a copy of earlier, and which I've included the relevant page for in appendix to the brief. We did formalize that aspect of discovery, whereby the prosecuting attorneys did not have to turn over their attorneys' notes of witnesses. The reason for that, and the common sense behind it, and the reason why that is okay, that we are asking for their notes, even though we're not turning over ours, is because in every instance where witnesses testified, we have had a police detective or a DA investigator interview that witness and write it up in a statement form, coherent statement, and have given that to the defense so that they have that, so that they had no need for attorney's notes. On the other hand, there are a lot of civilian, as opposed to expert, lay witnesses which the defense has failed to give us any information on at all. And there are also, in addition to that, approximately 10 or 11 witnesses for whom they have provided only rough notes. And I made a copy of those. I know I appended one to our brief, but I did make a full, I believe it's a full set for the court's perusal with regard to the other witnesses that I didn't append to the brief, to show the court just how loose these notes are and how unreliable they are. We cannot rely on these. We cannot rely on these in either of two ways. One, we can't rely on them for notice of what the witness is even going to say. Most of them, many of them do not even include relevant dates or time periods or what it is exactly they're alleging. You have to try and read between the lines. So there's an obvious due process problem, which is not satisfied by these notes and which does not satisfy the discovery statute. In addition, there is the problem that we do not have anything concrete upon which to cross-examine these witnesses for whom we've been provided either no discovery or these rough notes. We cannot expect a witness to testify consistent with something that is incomprehensible. And so therefore, if the witness testifies differently from what they said, we're not going to know it because you cannot tell from these notes. Therefore, there's nothing in these notes with which we can impeach them. So it provides almost nothing. The only thing it gives us is some rough idea of the nature of the subject matter of the testimony. It does not tell us what they would say, what their statement would be, what it is that they believe to be the truth that they would testify to. So for the defense, on the one hand, to say, well, we have this agreement where we're not going to give you attorney's notes, but on the other hand, either withhold discovery entirely on many witnesses or give us only these...
I know we passed the 2-hour mark a minute ago, but she has not stopped to breathe. She just hasn't. We just have to keep going till she needs oxygen. Then we can pause.
Inadequate, undecipherable rough notes with regard to these 10 or 12 witnesses. It's just not fair. They just don't come into court in equity with clean hands and be able to force us to abide by that early informal agreement because they have not abided by the discovery laws and the spirit of that agreement, whereas we have in providing them witness statements from police or DA investigators with regard to all these witnesses. So we believe, Your Honor, with regard to the lay witnesses or non-expert witnesses, they should be required to either have their investigator write a coherent, I should say, an understandable, intelligent, understandable statement with regard to what these witnesses would say, or give up their notes. I mean, they cannot shield themselves with this informal agreement we had earlier when they're using it to violate the discovery laws.
That was finally a break, no matter how tiny. Whew. Woman, jeez, come on. I lost track of what she was saying because it just was... All right, we made it through that one. Oh, man, it's 9:22 already. Guys, man, I gotta go to work any minute now. That sucks. Please take today off, all of you. Don't go to work today, especially you, Josh. You work way too hard. Relax. Eat some chocolate. I shall see you all very, very soon. Thank you so much for coming out. I really appreciate it. I do. I hope that you guys have a great day. Bye, guys. Tell her to calm down. Now I have to say goodbye all over again. Calm down. Bye, guys.